The Supreme Court just dropped a bombshell that nobody saw coming, a rare unanimous 9-0 ruling that fundamentally rewrites the balance of power between federal agents, state courts, and local law enforcement. And it landed at the worst possible moment, while Minnesota is experiencing a constitutional crisis that has left residents, federal agents, and state officials in a standoff that's been escalating for the past 72 hours. This isn't just another dry legal decision buried in court documents. It's a nationwide earthquake that changes your rights the next time any badge shows up at your door, and it's taking effect immediately. No waiting period, no phased implementation. Federal officers operating in Minnesota right now learned about these new rules from alerts on their phones this morning, and what happens over the next 96 hours will determine whether this ruling prevents chaos or triggers it nationwide. Before we unpack why all 9 justices from Sotomayor to Thomas found common ground on this explosive issue, hit subscribe because the legal revolution unfolding right now will affect every American regardless of where you live. Let's cut through the legal jargon and explain exactly what the Supreme Court did. In a massive opinion that spans multiple companion cases, the justices unanimously struck down decades of legal doctrine that governed how federal and state law enforcement coordinate operations and how state courts interpret federal law. The majority opinion, authored by Chief Justice Roberts but joined by every single justice, including the 3 liberal appointees, represents the most significant unanimous decision on federal-state relations in over a decade. Here's what makes this so explosive. The court addressed 2 critical issues in parallel rulings that arrived within hours of each other, and together they're creating a perfect constitutional storm. First, in the law enforcement coordination case, the court ruled that federal agents can no longer operate within state territory without following state-established coordination protocols. For decades, federal officers could execute warrants, make arrests, and conduct searches by simply flashing a badge and claiming federal authority. That's over. The court declared this practice violates the 10th Amendment's anti-commandeering principle. When federal agents operate inside a state without coordination mechanisms established by that state's legislature, they effectively conscript state resources, including roads, emergency services, and public safety infrastructure, to execute federal policy. The Constitution doesn't allow the federal government to commandeer state sovereignty this way. Second, in the state court interpretation case, the court ruled that state courts have been fundamentally misinterpreting the supremacy clause when it comes to enforcing federal law. For 40 years, state courts in 23 states have developed their own interpretations of federal statutes, often providing more generous remedies or broader liability than federal courts would allow. The Supreme Court just said that entire framework is unconstitutional. State courts can no longer create their own standards for enforcing federal law when those standards are more restrictive or more generous than what federal courts would apply. This affects everything from employment discrimination to consumer protection to environmental enforcement. Translation? Your rights under federal law now depend entirely on federal court standards, and federal agents must follow state coordination rules to operate. Both changes take effect immediately, and Minnesota is ground zero for watching this play out in the most dangerous way possible. 3 days ago, a routine federal drug enforcement operation in Minnesota collided with a state law enforcement operation targeting the same location. Neither agency knew the other was moving. When federal agents breached the property at 6:14 in the morning, they encountered armed state investigators who, operating under Minnesota's strict warrant restrictions, mistook the uncoordinated federal entry for a home invasion. Shots were fired. No fatalities, but 2 state investigators were hospitalized. That single incident triggered Minnesota Governor Tim Walz to activate an emergency provision in the state's Public Safety Act called an emergency jurisdictional freeze. Under this statute, when federal and state operations conflict within state boundaries, the governor can temporarily suspend all federal enforcement actions until protocols are reestablished. Governor Walz issued the freeze order Tuesday night, 8 hours before the Supreme Court released its ruling Wednesday morning. So now we have a perfect constitutional storm, a governor exercising emergency powers to block federal operations based on state law, while the Supreme Court simultaneously rules that federal agents never had constitutional authority to operate without state coordination in the first place. The Department of Justice filed an emergency motion within hours, arguing the governor's freeze exceeds state authority. But here's what DOJ lawyers aren't saying publicly. Their own internal memos from 2 years ago acknowledged this exact scenario was legally precarious. A leaked opinion from the Office of Legal Counsel warned that continued reliance on uncoordinated federal enforcement creates significant vulnerability to 10th Amendment challenges. The administration chose to ignore that warning while prioritizing immigration and drug enforcement metrics. Now that vulnerability has exploded into a full-blown crisis on the streets of Minnesota, but there's a sleeper provision buried in the court's opinion that almost nobody noticed yet, And it's the part that transforms this from a jurisdictional dispute into a tool that states and counties can weaponize. It appears in a concurrence by Justice Kagan, just 87 words that legal scholars are already calling the sovereignty trigger. Here's what it says. Nothing in this opinion prevents states from establishing opt-out registries whereby local jurisdictions may formally decline participation in specific categories of federal enforcement actions, provided such declinations are enacted through transparent legislative processes rather than executive fiat. In plain English, the Supreme Court just greenlit a constitutional pathway for counties and cities to formally refuse cooperation with federal law enforcement on specific policy areas like immigration raids, drug interdiction, even certain financial crime investigations, without triggering federal preemption challenges. Minnesota's legislature, anticipating this exact scenario, passed the Local Autonomy Enforcement Act 6 months ago, creating precisely the transparent legislative process Kagan referenced. The law established a digital registry where county boards can vote to opt out of federal enforcement categories by simple majority. As of 9:47 this morning, 43 minutes after the ruling dropped, sheriffs in 7 Minnesota counties had already filed opt-out declarations. 4 counties declined all immigration enforcement cooperation. 2 rejected federal drug task force participation. 1 county opted out of everything: immigration, narcotics, firearms trafficking, even federal witness protection operating within their borders. The sheriff there put it bluntly in his press conference. My deputies answered to the voters of this county, not to a U.S. attorney who's never set foot in our jurisdiction. If federal agents want to operate here, they coordinate through my office, or they don't operate at all. This isn't sanctuary city rhetoric anymore. It's constitutional doctrine blessed by a unanimous Supreme Court. Within hours, attorneys general in Vermont, Oregon, and New Mexico issued statements confirming they'd activate similar opt-out registries within 24 hours. Texas and Florida announced they'd pass legislation requiring all counties to cooperate with federal enforcement, setting up an inevitable collision where state law demands cooperation while the Supreme Court just affirmed localities' right to refuse. But here's the terrifying gap nobody's addressing. What happens when federal agents ignore these opt-outs? The ruling strips federal courts' power to force state cooperation, but it doesn't criminalize federal agents who operate anyway. It creates a constitutional gray zone where federal officers could still enter opt-out counties and make arrests, but that evidence would be inadmissible in federal court, and the agents themselves could face state charges. This exact scenario unfolded in Wright County, Minnesota, where 2 immigration agents attempted to serve deportation orders at a facility 30 minutes after the county filed its opt-out declaration. When county sheriff's deputies arrived and ordered the federal agents to stand down, one agent reportedly responded, "You don't have authority over federal immigration enforcement." The sheriff's body cam footage shows the standoff lasting 11 minutes before the federal agents retreated. The template is now set, and the next confrontation might not end peacefully. While politicians debate doctrine, real people are trapped in the enforcement gap, and the human cost is accumulating hour by hour. Let's talk about what's happening to domestic violence victims in opt-out counties, a crisis unfolding right now that transforms abstract sovereignty debates into life-or-death emergencies. Maria Flores is a pseudonym for a real woman in a Minnesota county who called 911 yesterday after her husband threatened her with a firearm. Under the Federal Violence Against Women Act, she qualified for emergency relocation and witness protection through the U.S. Marshals Service because her abuser has a prior federal firearms conviction. But her county filed its opt-out declaration this morning, specifically declining cooperation with all federal witness protection and victim relocation programs. When county deputies arrived at her home, they confirmed her eligibility for federal protection, but explained they could no longer facilitate contact with U.S. Marshals. The deputies offered state-level resources, a local shelter with a 3-week waiting list, a restraining order that her husband has violated twice before, and the grim advice to stay with family if possible. Maria Flores hasn't been heard from since 3 in the afternoon. Her phone goes straight to voicemail. This isn't isolated. The Minnesota Coalition for Battered Women has documented 12 similar situations in the past 18 hours. Women who qualified for federal victim protections now stranded in enforcement limbo because their counties opted out. The Supreme Court's opinion mentions none of this, not once. The 9 justices who unanimously reshaped American federalism never grappled with the human consequence of their elegant constitutional theory that sovereignty disputes create protection vacuums where the most vulnerable fall through cracks. Federal programs that require local coordination to function are now facing potential fragmentation. The Victims of Trafficking and Violence Protection Act mandates that federal coordinators work through local law enforcement to identify and extract trafficking victims. The Elder Justice Act relies on county protective services to flag financial exploitation cases for federal prosecution. Even Amber Alerts depend on seamless federal, state, local communication to broadcast child abduction alerts across jurisdictional lines. All of these systems now face potential breakdown in opt-out counties. The Department of Justice activated its emergency coordination cell, but internal emails obtained by journalists reveal panic. We have no playbook for operating in a patchwork sovereignty environment. Our entire victim protection infrastructure assumes baseline cooperation. Without it, we're blind. Meanwhile, advocacy groups are filing emergency motions arguing that certain federal protections implementing treaty obligations cannot be subject to local opt-outs without violating international law. But those legal challenges will take months or years. The women in Minnesota don't have months. And while this enforcement crisis unfolds, the second part of the Supreme Court's ruling is detonating a completely different bomb in state courtrooms across America. Within 90 minutes of the decision being published, the Minnesota Attorney General's office filed emergency motions in 11 separate pending cases, all of which involve state court interpretations of federal law that are now constitutionally invalid. Legal experts estimate that 15,000 to 20,000 currently pending state court cases across the country are directly affected because they rely on state court interpretations of federal law that exceed what federal courts would allow. Here's why this matters to ordinary people. Employment discrimination law is the single biggest area where state courts have interpreted federal statutes more broadly than federal courts, and this ruling just eliminated decades of state-level precedent in one stroke. California state courts have allowed employment discrimination cases to proceed to trial on significantly less evidence than federal courts would require. That entire body of precedent is now constitutionally invalid. The same applies to age discrimination, disability rights, and family medical leave, where at least 17 states developed their own more generous interpretations of federal standards. New York courts have been particularly aggressive, allowing hostile work environment claims to proceed based on conduct that federal courts would find insufficient. Every pending employment case in New York State court that relied on this more generous standard is now vulnerable to dismissal. For workers, this means behaviors or policies they thought were illegal under federal law might actually be permissible when judged by the stricter federal standard. The National Employment Law Project estimates that approximately 12,000 workers currently serving as named plaintiffs in state court employment cases will see their cases dismissed or significantly weakened in the next 90 days. Worker advocacy groups are calling this a corporate get-out-of-jail-free card, while business organizations frame it as necessary correction to state courts overstepping their authority. Consumer protection litigation is experiencing the same seismic shift. State courts in 23 states have interpreted federal consumer protection statutes more favorably for consumers than federal courts do, particularly the Fair Debt Collection Practices Act, Truth in Lending Act, and Telephone Consumer Protection Act. This ruling just invalidated all those more generous interpretations. Florida state courts alone have been responsible for approximately $4.7 billion in consumer protection settlements and judgments since 2015, many based on interpretations more consumer-friendly than federal court standards. Every pending case in Florida state court is now subject to challenge under this new framework. Major class action settlements negotiated based on state court standards are being challenged. Defense attorneys are filing motions to vacate settlement agreements approved in the past 12 months, arguing the settlements were based on legal standards the Supreme Court has now declared unconstitutional. If those motions succeed, consumers who thought they were getting settlement checks might find those settlements unwound and their cases dismissed entirely. Government agencies at the state level are suddenly facing a crisis about their enforcement authority. Many state attorneys general have brought enforcement actions in state court based on federal statutes, using their state courts' more expansive interpretations to hold corporations accountable for conduct that federal agencies might not have prioritized. Washington State's Attorney General has 34 active consumer protection cases that cite federal law, with many relying on state court precedent that interprets federal statutes more broadly than federal courts would. Defense counsel filed motions this morning arguing the state's entire enforcement strategy is now constitutionally invalid. Similar motions are being filed in Massachusetts, Oregon, and 11 other states. Environmental enforcement is particularly affected. State environmental agencies have brought hundreds of cases alleging violations of federal environmental statutes, often securing relief that federal courts might not have awarded. Clean Water Act cases are the most prominent example, with state courts in 7 states having interpreted federal water quality standards more strictly than federal courts typically do. Every one of those interpretations is now subject to challenge. What makes this frustrating for state regulators is the resource imbalance. Federal agencies like the EPA and FDA don't have the budget to pursue every violation of federal law, which is why state attorneys general stepped in to fill the enforcement gap. If this ruling prevents state courts from interpreting federal law expansively, it creates a potential vacuum where violations go unpunished simply because federal agencies lack capacity to address them all. The unanimous nature of this decision is what makes it truly bulletproof. When the Supreme Court divides 5-4, clever lawyers can find cracks in the logic and lower courts have room to distinguish cases. But when it's 9-0, the door is shut. The justices have sent an unmistakable message to every judge in America: stay in your lane. This is the third major decision in 18 months where a unanimous or near-unanimous court has slapped down state courts for exceeding their authority in interpreting federal law. The pattern represents a systematic effort to assert hierarchical control over state court interpretation of federal law in a way that hasn't been seen since the 1950s. What's really happening is the Supreme Court reasserting total dominance over the federal-state relationship. By issuing unanimous decisions, the court is effectively bulletproofing its authority. You can't claim partisan hackery when Sotomayor and Thomas are signing the same opinion. This is a strategic move to insulate the court from political attacks. In a country tearing itself apart with states at war with the federal government, the 9 people in black robes are positioning themselves as the only ones holding the line, the ultimate referees with zero room for lower courts to interpret differently. But that institutional power play creates a fundamental paradox. The court is telling state courts they must defer to federal interpretations of federal law, which sounds like federal supremacy. Yet the practical effect might be reducing overall enforcement of federal law, because state courts have been more aggressive enforcers than federal courts in many areas. If state courts were correctly interpreting federal law more generously because federal courts have become too restrictive, then this ruling makes it harder to vindicate federal rights. If state courts were overstepping and distorting federal law beyond what Congress intended, then this ruling restores proper balance. Minnesota tonight stands at a crossroads that will determine whether this ruling strengthens our federalism or fractures it beyond repair. Federal agents are standing down at county lines while sheriffs decide whether to grant them entry. Domestic violence victims are trapped in protection gaps with nowhere to turn. Thousands of employment and consumer protection cases are being dismissed based on legal standards that were valid on Monday but invalid on Tuesday. State environmental enforcement is grinding to a halt as defense attorneys weaponize this ruling to escape accountability. The Supreme Court handed us a doctrinally pure solution to messy constitutional problems, but doctrinal purity on paper often breeds brutality on the ground when human lives depend on seamless coordination between government layers. We're moving into a reality where your rights under federal law depend entirely on which county you're standing in when you need protection, where sovereignty becomes a barrier to survival rather than a shield for liberty. The question isn't whether the law was followed. The question is, who gets to decide what's reasonable in a country that can't agree on anything? One thing is certain, the rules of the game will never be the same. If you want to stay ahead of the next major constitutional shift, make sure you're subscribed. Drop a comment below. Does a unanimous ruling make you feel safer, or does it make you more afraid of what's coming next? Because what happens in Minnesota over the next 72 hours will determine whether America's federalism survives this test or collapses under the weight of its own constitutional perfection.